Good afternoon, everyone. My name is Andrei Demidov. I work as the scientific coordinator at the Institute for Advanced Study in Budapest at Central European University. And it's my pleasure to welcome you at our online event titled Drawing Lines, Humor, Free Speech, and Hate Speech. It's a part of a larger project titled Cartoons in Court towards a forensic analysis of visual humor, supported by the Constructive Advanced Thinking program. Before we start our event, allow me to share several words about the Constructive Advanced Thinking program, also known under the acronym CAT. It is a joint initiative of the European Network for Advanced Study, launched in 2019, which supports groups of early career promising scholars who wish to address emergent societal issues in their projects. It supports interdisciplinary teams and up to 5 scholars led by a principal investigator. The program allows teams to spend up to 5 visits in different institutes for advanced study across Europe. And it fosters exchange of ideas, cooperation, and supports teams in the implementation of their projects. We at the Institute for Advanced Study in Budapest are happy to be a coordinating institution for the team led by the principal investigator Alberto Godioli, who applied with the project, as I said, Cartoons in Court towards a forensic analysis of visual humor. Today, we asked the group to present the project, and we have the whole team with us, joining us this afternoon. And allow me to introduce the members of the team. So, as I said, the team is led by the principal investigator, Alberto Godioli, who is a senior lecturer in European culture and literature at the University of Groningen and program director of the Netherlands Research School for Literary Studies. We also have with us Vicky Bremen, assistant professor at Utrecht University's Center for Intellectual Property Law, Andrew Breaker, assistant professor of English literature in the Department of Literary Studies at Ghent University. We also have Anna Pedrazzini, researcher in communication and semiotic studies at Comahue National University in Argentina, and Tjeerd Royerts, an award-winning Dutch editorial cartoonist currently living in Amsterdam. We will be happy to host the team in March 2021, but before that, we're also very excited to host this event and to hear what the team has prepared for us all. Without further ado, Alberto Godioli, the floor is yours.
Hi, Andrei. Many thanks for your introduction and in general for all your help organizing this. We would also like to thank Enetias and the Budapest Institute in particular and Cartoon Movement for all their support and for making this possible. We're very happy to be here. So the idea is that I'm going to start with a short general introduction to the project, 5-7 minutes, more or less, and then we'll move on to the short presentations by the team members, which will be followed by the open debate. So in a nutshell, the key question behind our project and behind today's event as well is the question that is often phrased as follows. How can we draw a line between one's right to offend and someone else's alleged right not to be offended? So this is a very frequently asked question, and it's also a very tricky one because both these categories, so the right to offend and the right not to be offended, are quite vague. And one might argue that either or both of these categories don't really exist in a proper legal perspective. So less catchy, but perhaps more accurate way of phrasing this question could be the following. To what extent can extreme speech be protected under freedom of expression? By extreme speech, we mean a broad range of potentially offensive expression which can span from insult and defamation all the way to blasphemy and hate speech, so speech that promotes or incites hatred on the basis of sex, race, and religion, and so on. So visual humor and cartoons in particular often play with the boundaries of various forms of extreme speech and often get into some kind of legal trouble because of that. Just one relatively recent example here is cartoon by Sharp that was published by Charlie Hebdo in January 2012, so some time ago now, with the caption, "Le Pen, the candidate who resembles you." This cartoon was at the center of a long legal dispute that started in 2012 when Marine Le Pen, a far-right French politician, sued a TV presenter for showing this cartoon during a Saturday night show. And only in October 2019, the French Court of Cassation acquitted the TV presenter for showing the cartoon. So this is just one of several examples that we can think of legal cases revolving around visual humor and cartoons in particular worldwide. It seems fitting, though, that we are starting today's event with an example from Charlie Hebdo. We will also discuss more cartoons from Charlie Hebdo later on during the presentations, also as a way to acknowledge the importance of Charlie Hebdo in recent and ongoing debates about the limits of freedom of speech, freedom of expression. And this seems, as I was saying, particularly fitting today, also taking into consideration the recent start of the trial for the 2015 terrorist attack against Charlie Hebdo. Okay, as I was saying before, there are plenty of other examples you can think of legal cases revolving around visual humor and cartoons all over the world. These cases do seem to get more and more frequent and topical in the so-called digital age, where potentially offensive material can easily circulate globally and often outside of its original context. As stated, in the 2019 Addis Ababa Declaration for the Recognition of Cartooning as a Fundamental Human Right, the development of the internet, a tool that circulates cartoons from all over the world instantly, thus favoring their decontextualization, has fueled tensions and feelings around this means of expression. So it's all the more important today to make sure that we protect freedom of humorous expression, of cartooning in particular, while at the same time reflecting on the responsibilities that come with free speech and freedom of humorous speech as well in the digital age. This kind of reflection is particularly challenging and complicated in the case of cartoons, precisely because we are dealing with a particularly compact and condensed form of communication, one that is often characterized by a high degree of ambiguity and implicitness. And the challenges posed by the ambiguity of cartoons often have serious legal implications, as is shown by the high level of inconsistency in the legal handling of visual humor and of cartoons in particular. And indeed, if we take a closer look at case law regarding cartoons, not only across different socio-political contexts, but also within the same given court, for instance, the European Court of Human Rights, we can easily notice several forms of inconsistency and fragmentation in the ways in which cartoons are dealt with in court. This is basically what our project is about, trying to map these forms of inconsistency and to possibly harmonize and improve the court's approach to humor. So these are the two fundamental questions behind our project. How do courts deal with the ambiguity of visual humor, and how can their approach be improved or harmonized? And when we talk about courts in the framework of this project, we mostly refer to European courts because, as we will also argue later on during the presentations, we think that the European context is a particularly useful starting point for comparative analysis, precisely because of its internal diversity, but at the same time, we plan to expand our scope to non-European case studies as well in the course of our project. So in order to tackle these two questions, we need an interdisciplinary team, which is what we have here. We have two humor scholars from a literary background, Andrew Bricker and myself. We have a law scholar, Vicky Bremen, a media scholar, Anna Pedrazzini, and a cartoonist as well, Chair Roy Arts, who is the director of Cartoon Movement. So by working together, we will try and tackle these questions by means of following four different but interrelated research strands, which are listed here. Number one, analysis of legal cases about controversial cartoons. Number two, analysis of ambiguity in cartoons from a semiotic and rhetorical perspective. Third, historical contextualization of cartoon controversies. And lastly, we will have a series of interviews with cartoonists and legal practitioners. So this is our project in a nutshell. In the next 30 minutes, more or less, we will give you a taster of the project with our short presentations. I will start then right now with my pitch about cartoon controversies and free speech in Europe. And I will also try and present my own approach to these controversies, which is what I try to define in my research as forensic humor studies. Okay, so I will start right now. When we talk about free speech controversies in Europe, the best starting point is always the European Court of Human Rights, which is the ultimate authority in the field and also serves as the main reference point for liberal democracies across Europe and beyond Europe as well, also when it comes to the regulation of free speech. The European Court of Human Rights doesn't really have one consistent and, let's say, codified approach to the regulation of free speech, but at the same time, as pointed out by recent scholarship, there is a growing trend at the European Court of Human Rights, but also in Europe at large, towards adopting the following rule of thumb, which is extreme speech is usually protected under freedom of expression when it merely causes offense on a subjective level, while it tends to be somehow restricted or regulated by law when it objectively harms somebody's status in society, as is the case with incitement to hatred, discrimination, or violence. So this is a bit of a different situation and a more complicated one than what we find in the United States, for example, where free speech is only really interfered with in the case of so-called true threats. That's to say, speech that clearly and directly threatens someone's physical safety and health. In Europe, instead, you have a much bigger gray area of extreme speech that kind of falls between subjective offense and objective harms and may or may not be restricted by the law. And this gray area is in fact even more vast in the case of cartoons, precisely because we are dealing with an often elusive and ambiguous medium of communication. In order to illustrate this point, I would like to discuss one concrete example, once again from Charlie Hebdo, this cartoon by Riss that was published in October 2015 with the caption Morano, de Gaulle's hidden daughter with Down syndrome. Now, Nadine Morano is a right-wing French politician who a few days before the publication of this cartoon had stated the following: we, France, are a Judeo-Christian country, a white race country, like General de Gaulle used to say. So in order to satirize Morano's alleged ideological lineage, so her claim of being somehow the political heir of General de Gaulle, Riss is kind of portraying her as de Gaulle's daughter, which is also a reference to his actual daughter Anne, who had Down syndrome. So as you can see, it's a very controversial cartoon, and in December 2015, the French Collective Against Ableism sued Charlie Hebdo over incitement to hatred and discrimination towards people with Down syndrome. And the trial went through 3 different stages. The first instance in January 17, then the Court of Appeal, and lastly the Court of Cassation. Notably, in 2017, the Court of Appeal argued that the cartoon was not offensive to people with Down syndrome, while in 2019, the Court of Cassation kind of changed that and ruled that the cartoon does offend people with Down syndrome, although it doesn't directly incite to hatred or discrimination. So The verdict by the Court of Appeal wasn't really overturned by the Court of Cassation, but at the same time, there is a significant change there. And I think that this case does exemplify a much broader trend, which I could identify in my previous research on cartoon controversies, which is a fundamental lack of a shared terminology and a consistent approach to the following key questions. Number one, what are the possible interpretations of a given ambiguous cartoon? And number two, provided that the same cartoon allows for multiple interpretations, say offensive interpretation and a less offensive one, then to what extent should the author be held responsible for the possibly offensive and harmful interpretation of the cartoon? Cases of ambiguity, how do we ascribe responsibility to the cartoonist? So in order to tackle these two questions properly, my point is that we need a closer interdisciplinary dialogue between the law on the one hand and humanities-based humor studies on the other hand. And this is what I try to define as forensic humor studies in my research. So I'm going to give you a quick example of how this dialogue can take place in practice by way of focusing on this cartoon and on these two issues in particular. So let's start from the first point here. What are the possible interpretations of the cartoon? In this specific respect, we can say that humor theory helps us identify two fundamentally different forms or types of potentially offensive humor, potentially offensive cartoons in this case, which is what I try to define in a recent contribution as a first degree offense on the one hand and a humor against the offender on the other. This distinction is partly inspired by the work of Paul Simpson on the discourse of satire, but we don't really have the time to delve too much into the theory here. I will just focus on our specific case here. So if we interpret the cartoon as an example of first degree offense, this means that we somewhat conclude that Down syndrome is being used here as a pejorative term, which clearly implies an offense towards people with Down syndrome. And this is the position that was taken by the Court of Cassation in 2019, for instance. While if we interpret the cartoon as an example of humor against the offender, then we conclude that the pejorative use of Down syndrome shouldn't be meant in the first degree, but it's rather a way to mirror or echo and satirize Morano's own racist and thereby eugenic and discriminatory rhetoric. Remember when she talked about France as a white race country. So they kind of echo this violent discriminatory rhetoric and turn it against an even more visibly vulnerable target, such as children with Down syndrome, and thereby expose the inhumanity and brutality that is inherent to Morano's own rhetoric. So this is a bit more of a subtle interpretation of the cartoon, a more complicated one, and one might argue more far-fetched, but it's definitely more in line with the usual style of Charlie Hebdo and of Riis in particular, who often uses racist, xenophobic, ableist rhetoric to an exaggerated degree as a way to undermine it and as a way to satirize and expose the inherent inhumanity of this kind of rhetoric. So it's a very tricky game that is being played here. So we have this kind of ambiguity between these two forms of potential offensive humor in this cartoon here. But the point is that even if we accept this second interpretation, if we think that it's plausible that Down syndrome is being used here not as a pejorative term, but in the second degree, so even in this case, we are still left with the other key problem here, which is to what extent then should the cartoonist or should Charlie Hebdo be held responsible for the other interpretation, for the possible offensive, harmful interpretation that is still allowed for by this cartoon. So the usual approach that is used by courts in these kind of situations is to rely on the notion of the reasonable audience, the reasonable public, and which means basically that the cartoonist, the author, is held responsible for how the cartoon could be interpreted by a reasonable interpreter. Now, what does reasonable really mean here? One might ask, and how do we apply this very general notion to the specificities of a concrete case. I think this is also an area where interdisciplinary dialogue can help. And I'm thinking in particular of the notion of presumed addressee, which is defined in literary theory as the public that the author can presume to be talking to. So that is, I think, a more specific notion than the notion of reasonable audience. And yeah, I still hear some kind of background noise. Do you also hear it, or is it only me? Okay, so probably it's just coming from. Yeah, sorry. I was just saying that the notion of presumed.
I can also hear background news. I see that 3 or 4 people have still their
the mics on,
not unmuted. Yeah.
Yeah. Thank you. Yeah. So it would be great if
Mira, Mercedes, Julia are not unmuted.
Okay. Thank you. Yeah. So it would be great if you could switch it off. Sorry. Thank you. So I was just saying that the notion of presumed addressee is somewhat more context specific than the notion of reasonable audience, and it might help us better understand the case of Charlie Hebdo here. Because if we think about the trajectory of Charlie Hebdo over the last 15 years, more or less, we can notice a substantial change, not in the reasonability of the audience, but rather in the presumed addressee of the magazine. So in the kind of public that the magazine can presume to be addressing. This is something that was touched upon by another Charlie Hebdo cartoonist, Luz, in 2015, in an interview that he gave soon after the terrorist attack. And I'm reading here from the quotation: "Since the cartoons of Muhammad, the irresponsible nature of our cartoons has gradually disappeared. Since 2007, our cartoons are read literally. We are simply a newspaper that is bought, opened, and closed. If people post our cartoons on the internet, if the media highlights some of our cartoons, that's their responsibility, not ours." So Luz here is acknowledging the fact that there has been a change in the readership, in the presumed addressee of Charlie Hebdo, from a niche readership that was supposed to get the irony, so to speak, so to read the cartoons in the second degree, to a much broader global readership that tends to or is expected to read the cartoons literally in the first degree. So Luz here is tapping into a key question that I would like to leave you with, which is, to what extent should the cartoonist be held responsible, or how does the responsibility of the cartoonist change when there is such a significant change in the presumed addressee of the cartoons, so from a niche readership to a global audience? Now, the position taken by Luz here is quite clear. So in his view, the responsibility doesn't change, and the cartoonist has a right to be irresponsible in that sense. So we may agree or disagree with Luz here. We clearly don't have the time to come up with one univocal answer to this question right now. My main point is just to stress that in order to tackle this question in a proper and articulate way, we need a closer interdisciplinary dialogue between the law and humanities-based humor studies. And this is the end of my short presentation. There are some references here. You will also find them in the PowerPoint that we will upload onto the website of the institutes. And now I would just like to give the floor to Anna Pedrazzini, who will further elaborate on the notion of ambiguity in cartoons from a semiotic and rhetorical perspective. Thank you very much, and I'll just give the floor to Anna.
Thank you very much. Good morning, good afternoon to everyone, and thank you for joining us today. Well, my contribution to this roundtable will be to bring into the debate semiotic and rhetorical aspects that undoubtedly play a role in humor and cartoon controversies. As stated in our project, judges can benefit from a systematic methodology to analyze these rhetorical and semiotic aspects. A quick approach to legal rulings in Occidental countries in which humorous and satirical manifestations are in debate shows that discursive features are usually taken into account in the decisions made at court. Well, firstly, I would like to refer to a thesis I've been working on for many years, and it consists on claiming that in spite of local cultural specificities, humor presents regularities that allow us to consider it as a transcultural. A second claim, and related to this, is that the cartoons can be considered a discursive genre. So, well, in order to approach to this discursive genre, regularities can be identified in different dimensions, such as a thematic dimension, a pragmatic dimension, a modal dimension, and a rhetorical dimension. An enormous diversity of topics can be addressed in cartoons, and controversies, you can go to the next one, please, can arise with regard to politicians and politics, religion, show business, among others. I think it will be very interesting to analyze which are the most frequent topics in the corpus considered in our project. Another important aspect is to take into account the author's motivation, which may range from reflective social commitment to playful entertainment. Well, in the corpus of cartoons we consider in this project, cartoonists present a particular standpoint about a social, political issue with the aim of alerting people and making them reflect upon it. So usual effects on the readership are perplexity and shock. Well, cartoons are usually multimodal texts. This means that different semiotic modes are combined to convey meaning and create humor. So drawing can appear alone, but also in an interaction with writing. And sometimes other modes, such as maps and numbers, can also play a role in meaning making and humor creation. Another dimension, the rhetorical dimension, takes into account the resources that are deployed in the cartoons, as well as the arguments used to present a particular standpoint. So here, rhetorical figures, so figurative meaning, play a key role, such as metaphor, irony, metonym, allusion, antithesis. Cartoons are dense texts in which different layers of meaning frequently operate simultaneously. And along this line, a feature that makes cartoons particularly complex is related to the multiple voices that can be alluded to in a single cartoon. So the authors, the media, public figures, the doxa. So I will now analyze a controversial cartoon, taking into account these 4 dimensions. But before doing that, I think it's relevant to present a wider context in which the cartoon appeared. This case, I think it's a good example of intertextuality in media, and it's also an example of an increasing phenomenon which affects cartoons favored by internet and in particular social media, and that is the contextualization. As we know, the contextualization often leads to misreadings. So in the chain of events I'm going to present, the target is the French former Minister of Justice, Christian Taubira, during François Hollande's presidential term. 3 out of 4 of these publications that I'm going to show you were sued over incitement to discrimination and hatred. So the first event is when Anne-Sophie Leclerc, a candidate for the Front National, relayed on her Facebook page in October 2013 a photomontage comparing Christian Taubira to a monkey. The second event is when Minute, a far right-wing weekly, published an editorial titled Clever as a Monkey, Taubira finds the banana. So you can go to the next one, please. The person depicted in this caricature is Front National's former leader, Jean-Marie Le Pen. The third event is after the Minute's editorial, Charlie Hebdo publishes a cartoon created by Sharp. Well, this cartoon provoked some controversies. The next one, please. At the time, Sharp said, to denounce racism, sometimes it's necessary to represent the shocking image we want to denounce. So considering the aforementioned dimensions, from a thematic level, this cartoon refers to the Minister of Justice, Taubira, and the racist comments towards her from far right-wing partisans. From a pragmatic dimension, even if Taubira is depicted as a monkey, we identify an anti-racist intention in the cartoon due to its title, Rassemblement Bleu Raciste, in which Sharp makes a direct accusation towards the coalition of right-wing and far-right political parties created by Marine Le Pen, Rassemblement Bleu Marine. From a rhetorical dimension, there's a verbal substitution, so racist or racist instead of marine, navy. And also among visual resources, we find a caricature based on the use of zoomorphism. Depicting politicians as animals is a century long tradition in the history of caricatures. Well, there's also the symbol of Front National. Well, the fourth event is when André Giuliani, a right-wing French politician, published Sharp's cartoon, but without its title, Rassemblement Bleu Raciste. The blog's title was instead Parody of Justice. Important variations from the original version occur at the pragmatic and modal dimensions. So the social context of production changed. Sharp's intention was completely twisted. Giuliani's motivation is to criticize the harsh sentence towards Anne-Sophie Leclerc and the complete absence of accusation towards Sharp. You can go to the next one, please. Nevertheless, if we turn to the modal dimension, the visual verbal narrow relation of the original cartoon was broken. Without the words, and even more with a different title, the drawing presents a drastic change of meaning. So in the original version, the title contradicts the image. So we can ask, was there incitement to discrimination and hatred? Well, we might come back to this during the debate, so we'll stop here now. And well, thank you very much for your attention.
Thank you very much. So I think now it's Vicky's turn, right? If I remember correctly.
Yes, thank you, Alberto.
Thank you.
Well, today I would like to offer a legal perspective on satire, illustrated by the case Vereinigung Bildender Künstler versus Austria, or VBK in short. I will focus on 3 points. So I'll start with the position of art in the European Court of Human Rights line of case law. Then I'll outline the VBK case to concretize the court's view on satire. And finally, I'll draw attention to the definitions of satire relied on not only by the majority, but also by the dissenting judges. And I will also look at the different appreciation of the relevant factors to balance the interests involved. Okay, so first, as a bit of background, the court distinguishes different kinds of speech, including political speech, which enjoys the highest level of protection before the European Court, but also artistic speech is covered by Article 10 of the European Convention, and this provision protects freedom of expression in general. Well, in the line of case law before the court, no so-called exceptio artis has been recognized. So each time it's about the concrete circumstances of the case and balancing all interests involved. Yeah, so that's about artistic speech as such, but such speech can also contribute to a public debate, and then it enjoys more protection. But then again, this may be different if this contested artistic speech must be balanced against religious values or moral values of local or national communities. So that's a bit of background. And turning then to the VBK case, I should say that it was not a case about cartoons in particular, but it's still relevant to see how the court deals with the concept of satire. So what was it about? It was about a huge painting from an Austrian painter, which showed public figures in public figures, but also religious figures in sexual positions. And their bodies were painted, but their heads were blown up pictures. One of the figures featuring in the painting was the former General Secretary of the Austrian Freedom Party, Mr. Maisberger. He brought proceedings against the Artist Association and argued that the painting debased him and his political activities, and he aimed to prohibit any further exhibition of the painting. At the national level, he won the case, and then the Artists Association brought the case before the European Court, arguing violation of their freedom of expression. Well, ultimately, the court found that the injunction was disproportionate to the aim pursued, and indeed found a violation of Article 10. So it's interesting to see that the court explicitly goes into the concept of satire, giving the definition shown on the slide. But it just seems to come up in the reasoning, and that makes me wonder what this definition is actually based on, but also what the practical implications are for application in concrete cases such as the one at hand, especially since, well, it's this definition that underlies both the majority's view and that of two of the dissenting judges, as we will see in a bit. Well, the majority includes a number of principles and factors in its analysis. So first, the court repeats that Article 10 also protects information and ideas that offend, shock, or disturb. And this is a principle that often recurs in Article 10 case law. The court then goes on by stating that states may not encroach unduly on freedom of those who create or exhibit works of art, but also that freedom of expression comes with duties and responsibilities on the part of the artist, and that will depend on the situation and means. Well, regarding this specific painting, the court finds that it, and I quote, depicted Mr. Maisberger in a somewhat outrageous manner, but, and again I cite, it used only photos of the heads of the persons concerned, their eyes being hidden under black bars, and obviously did not aim to reflect or even suggest reality. So the court therefore concludes that such portrayal amounted to a caricature of the persons concerned using satirical elements. The court still goes on about the painting, stating that it related to Mr. Maisberger's public standing as a politician, so he had to display a wider tolerance in respect of criticism. The painting could, according to the court, also be seen as some kind of counterattack against the Austrian Freedom Party because its members had previously criticized the association's work. Another element in the reason of the court is that there had been an attack, and as a result, the offensive part of Mr. Maisberger's body was completely covered in red paint. So no longer that visible. And in the end, the court explicitly states to have balanced all interests involved. So Mr. Maisberger's personal interests and the association's freedom of expression. And it also indicates that the artistic and satirical nature of the portrayal has been taken into account, as well as the impact of the measure on the association. And then it leads to the finding that, as I said, this injunction was disproportionate to the aim pursued, and therefore not necessary in a democratic society. So as we see, satire is given quite a lot of legal space here, but I should say that not all judges agreed. If we look at the dissenting opinion of Judge Loukaides, he emphasizes the effect of the visible image on the observer. But then, as we have already talked about a bit, in our digital network environment, boundaries in time and place disappear. So who is the observer that should be taken into account? Another thing in the dissenting opinion of Judge Loukaides is that he questions whether the painting, which he consistently writes in quotation marks, even constituted art, stating that the fact that an image has been produced by an artist does not always make the end result artistic. And likewise, an image will not become satirical if the observer does not detect any message in the form of a meaningful attack or criticism relating to a particular problem or person's conduct. So in his view, so that is his view, no such message is present, and the painting can therefore not be called satirical or artistic. But what does not become clear from his statement is the definition of satire he relies on. So that was one judge, but there were two other judges who disagreed with the outcome of the case. And I should note that these dissenting judges cite the definition of satire given by the majority as well. So apparently it seems that the same definition can lead to a different outcome. And then it's mostly the factors considered in the balance of interests that they disagree with. So these judges agree that Article 10 also protects ideas that offend, shock, or disturb, but they find that the painting in question interferes excessively with the rights of others. And as they also quote, there are limits to excess. One cannot be excessively excessive. So according to these judges, in this case, the excessive nature of the portrayal results precisely from its attack on the dignity of others, which in their view is covered by the more general protection of the rights of others under paragraph 2 of Article 10. And as they also say, dignity is a concept that prevails throughout the entire European Convention. Well, then these two judges also endorse the finding in a German cartoon case that where there is a conflict with human dignity, artistic freedom must always be subordinate to personality rights. And they further substantiate this by citing law professor Barend, who, as the judges phrase it, rightly approved this decision by stating that political satire should not be protected when it amounts only to insulting speech directed against an individual. And so these judges conclude that the majority's reasons to find a violation of Article 10 are not even relevant, as these should be seen as subordinate to respect for human dignity. So to conclude, although the court ruled in favor of freedom of expression in this VBK case, this was only by a 4-3 majority, which indicates the fine line between permitted art and satire that crosses the line, meaning that this decision could easily have gone the other way and leaves us with a number of questions. Thank you.
And now I think I'm up.
Yes.
Wonderful.
Yeah, I will just then turn the page to, this is Vicky's thanks, and thank you, Vicky, also for your presentation. And now it's Andrew's turn. Yeah, here we go.
Great, thank you. So my contribution to this project is as a historian of satire in the law, and especially of 18th century English satire, so that some of these debates that we're addressing in this project, but also today, in relation to visual satire, such as semantic ambiguity, legal procedure, courtroom procedure, public opinion, are largely defined during the 18th century with the expansion of press freedoms in Europe. So in 1695, the Press Licensing Act lapses, and England becomes the only European country without pre-publication censorship. But the press during this period is not totally free. Instead, the Crown institutes a regime of post-publication prosecution, especially through libel laws and defamation laws. Written satire poses a particular problem throughout the 18th century, but it is visual satire that remains an emerging problem, and I think for an especially interesting reason. I tend to avoid the word cartoon, a word that only fully comes into use in the modern sense in the middle of the 19th century. I prefer the 18th century word, caricature, which was a new art form in the middle of the 18th century, a name that's derived from the Italian caricare, which Alberto can then correct my pronunciation of later, meaning to charge the features. So that caricature as a term not only defines the name for a type of object, but actually provides a description of its visual method, the heightening and distortion of an individual's physical features. So I thought we could sort of look at one example from the 18th century, and this is James Gilray's satire on the politician Charles James Fox from 1793. So at the center of this image, we have Fox, the great Whig politician. He's depicted as a kind of drunken, hairy, flatulent subhuman. And even worse, he is dressed in the shabby clothing of a sans-culotte or working class French radical. And he's standing there dancing a kind of bloody-handed jig and casually singing the popular revolutionary refrain, Satire, or It'll Be Fine. Even the title of the print was a slap in the face in 1793, when the term Democrat was little more than a provocative shorthand for an English Jacobin. This is why caricature, I think, not cartoon, is such a useful word. it highlights the feature that permitted visual satire, and specifically caricature, to continue moving away from more heavily verbal mediated forms. Alberto, could I get you to jump the slide? Thank you. Elsewhere, I've talked about caricature's closed system of representation, such forms of visual repetition that reduced the need for verbal expression. So here we can see Fox, not only his bell pepper nose and pendulous jowls and 5 o'clock shadow, but also in the visual mnemonic of his name. Charles James Fox was often simply represented as a fox. An increased emphasis on the semantic potential of the visual, for instance, insofar as satiric victims themselves became visually easier to identify among viewers. This increased emphasis on the semantic potential of the visual also led to a reduced reliance on words in visual satire, especially during the later 18th century and earlier 19th century. This deverbalization, as I've called it, produced in turn problems for the courts, which had come to understand reference, the meaning, for instance, of a given satire, in exclusively verbal terms. There simply existed no courtroom mechanism for converting a visual satire into a demonstrably seditious or defamatory set of words. And remarkably, the courts never quite solved the problem of visual semantics in satire, and how you might, despite the fact that there was this massive growth of caricature during this specific period. This brings us to the major issue already laid out by Alberto, but also raised by Vicky and Anna, this question of semantics, a problem demonstrated so clearly by the absolute profusion of words in this Charlie Hebdo cartoon. This cartoon sought to explain away the controversy around another cartoon, here the remediated image in the center that's in blue, that commented on the refugee crisis and the death of a young Syrian boy, Alan Kurdi, who washed up on the shore of Turkey. This cartoon is a perfect illustration, or better yet, verbalization of what I like to call the 1,000 words problem. The saying goes that a picture is worth 1,000 words, but visual satire always poses a much larger issue. An image might be worth 1,000 words, but which words in particular is never quite clear. The 1,000 words problem points to the extent that the issue is not necessarily ambiguity. With the Gilray image, there is in fact nothing ambiguous about the implicit accusation that Fox is an English Jacobin. The problem then is not ambiguity, but semantic indeterminacy, the recalcitrance of images and our inability to convert or transliterate them definitively into words. So that's one big issue that I want to take up with this project, and I know that all of us are interested in, this semantic issue around visual satire. But there's also a larger question which always circles around satire per se. Why, in fact, is visual satire so important? Why should it be a protected form of speech? And the answer to those kinds of questions is tied up in how we define the function of visual satire in today's world. Or, put slightly differently, between two extremes of officially sanctioned speech and a kind of First Amendment libertarian hyperprotectionism, we can imagine two situations. First, if we believe visual satire serves an important function or purpose, whether it's educational, social, political, or otherwise, then we are likely also to believe that it is a form of speech worth protecting. But second, if we believe visual satire does not serve a valid purpose and is instead simply incendiary, offensive, divisive, and so on, then perhaps we're more likely to permit greater restrictions on this sort of speech. Whether you end up supporting more or less regulation, I suspect your attitude towards legal restraint is conditioned or shaped by your attitude towards satire and your beliefs about it. This is why the function of satire is, for me, central to this project. Our beliefs about the function of satire foreground not simply the legal procedural issues that arise in regulating cartoons today. our beliefs about the function of satire foreground instead these fundamental issues about why we think visual satire is or is not a valuable art form with a clear or at least important role to play in today's world. And with that, I will throw to Chair. Thank you very much.
Thank you very much, Andrew. It's now Chair's turn.
Yes, and I think you all can probably guess which answer I have to Andrew's question. Because my name is Chair, I am the only non-academic of the group, although I do have a background in political science in a very distant past. But I decided to become an editorial cartoonist, and as such, my perspective on this project and my input on this project will be from the field, as I do a lot of cartoons myself. I work for a Dutch newspaper, NRC, and I also work for international media. And I'm also editor-in-chief of cartoonmovement.com, which is a website for professional international cartoonists. We have a community of close to 600 professional cartoonists who are on the website and publish there. And as you might imagine, we've had our share of controversial cartoons. We've been up and running for 10 years. So in that span, we had a bunch of cartoonists getting into trouble because of their work, including myself. But I'm not here to share one of those examples of myself, basically because it's very long ago. And I would spend the whole of my presentation explaining what the cartoon was about and why it was controversial. So instead, I decided to pick a recent example of a cartoon that got a Portuguese cartoonist in trouble. And I've called my presentation The Court of Public Opinion, because in our experience, in my experience running cartoon movement in the last 10 years, the cartoonists who end up in court are the ones in oppressive regimes. In Europe, cartoonists ending up in court is luckily still more rare, although Alberto did indicate that the number of cases is on the increase. And what we do see is that public opinion is getting more and more sharp when it comes to satire. And that's why I thought it might be good to share a recent example. Now, Alberto, you can now go to the slide of the cartoon that I want to share. So this is a cartoon. It's made by Portuguese cartoonist Vasco Gargalo. It was published in a Portuguese newspaper in 2019, November 2019. And he also uploaded it on our platform. The thing is, it was published in Portugal and it wasn't a problem. It was also published on Cartoon Movement and it wasn't immediately a problem, but a conservative Israeli think tank got wind of it like 3 months later. I think it was January 2020. And they sent a letter to the ambassador, the Israeli ambassador in Portugal, notifying him, and then the ball kind of got rolling, and in the end, other people started a petition and asked that this cartoonist be fired from the newspaper he was working for, and was to be fired from Cartoon Movement as well. And we received, I think, in total about close to 10,000 emails calling for the resignation of this cartoonist, because well, I don't think I have to explain the image. What he does is he criticizes Netanyahu's policy versus the Palestinians by making some very blatant comparisons to World War II. So it starts with Netanyahu with the blue armband around his arm, where in the Nazis would have a swastika. And he even included the famous slogan of concentration camps above the oven, where a coffin is put in, with the Palestinian flag. So the cartoon doesn't leave any ambiguity. It's a clear reference to World War II. It's a clear comparison to what Israel is doing to the Palestinians and comparing that to the Holocaust. What is interesting is a couple of points. It's the way that the public responded, and also what's mentioned by other people here in presentation, the decontextualization. So first of all, it's really interesting that a cartoon like this, which in the Netherlands, if I were to draw a cartoon like this, it would never get published in any newspaper, and I would know right away that this would cross a line, but apparently not in Portugal. So in Portugal, this was published without a problem, which is, to me, is really interesting and says something about how the standards are different in different countries, and how that's, you know, that's very difficult when it comes to judging satire, especially with cartoons, and you know, other people have already said this, but with cartoons having the potential to travel the world these days. And if you can forward 2 slides, I wanted to briefly mention this cartoon as well. It's interesting because this cartoon was also done by a Portuguese cartoonist, António Antunes. And it's also interesting because this cartoon was also published in a Portuguese magazine without any problem. And the problem didn't arise until it was picked up by the international New York Times. And I'm kind of guessing that everybody who's watching this Zoom meeting will have seen this cartoon, but this is a cartoon that was published in the international New York Times. It raised a storm of controversy in the US, but also in other countries, and eventually led to the decision about of the New York Times, the international edition at least, to stop running political cartoons altogether. So the first issue that we have that is interesting and that is very, very difficult is cartoonists making cartoons for a specific audience, and then it's getting either republished somewhere or getting picked up on social media and having a huge impact on another audience for which it wasn't originally intended. That's something that's already been discussed. But the second thing that is interesting and problematic of this court of public opinion is the consequences that it has for cartoonists. So in this case of Vasco Gargalo, everybody called for the termination of his contract. The public demands a very severe response, and sometimes they get that severe response, as in the case of the New York Times. So the cartoonist gets into trouble. Someone else said in a presentation somewhere that there is a joint responsibility between the cartoonist and the editor who's publishing it, which I think it is. You know, if a cartoonist gets into trouble because of a cartoon that's published in a newspaper, then it's also the responsibility of the editor who made the decision to publish it. But it's usually the cartoonist who ends up fired. So what we see happening in these cases is editors will get a slap on the nose, but the cartoonist will get fired. Or in the case of the New York Times, all the cartoonists will get fired. The controversy has severe consequences for us as a professional group. In the case of Vasco, he luckily wasn't fired from Sabado, but he did have to give back an award, a democratic award he received in France in the year before because of that cartoon, and also because of how the public opinion reacted to it. And I wanted to share that perspective on controversial cartoons, because obviously public opinion and how cartoons are seen and addressed in court are closely interrelated, in the sense that the evolution of public opinion will influence how courts look at freedom of expression, how courts decide on controversial cartoons. And that's why it's so important that we talk about the limits of freedom of expression and to what extent satire has the space to operate within those boundaries, because otherwise you end up with situations like this one. Okay, could you go to the next slide, Alberto? And that's also why I picked Israel as a topic, because Israel is obviously a very popular topic for political cartoonists to attack. It's very political. There's been a long-lasting conflict, and it's a subject that is very suitable for political satire. The problem with it is that you always run the risk of being called out as an anti-Semite if you do anything on Israel. As we've seen in the case of Vasco Gargalo, where it's quite clear, I think, that he crosses some boundaries, at least within the context of the Netherlands. But then with the cartoon of António Antunes, it's not so clear. You know, it's very debatable whether he crosses the line or not. the need to develop a clear set of boundaries, in particular when we're talking about Israel, comes into play with this cartoon. And after that, I'll quit and we can have a debate. But I wanted to share this because 2 weeks ago or 3 weeks ago, there was a discussion in the Netherlands because Facebook has decided to up its censorship of content that it considers anti-Semitic. So they will take a more aggressive role in removing content that they consider to be anti-Semitic from Facebook. And there was an interview with a pro-Israel organization in Dutch media, and who obviously thought this was a great idea. And this is one of the pieces of content that they shared as being anti-Semite or anti-Semitic, according to them, which I think is really problematic. But it also shows that the ambiguity that we have on what is satire and what is allowed, especially when you're talking about Israel, it makes it really difficult. Because to me and a lot of other people who see this cartoon, this is clearly just an editorial cartoon with very little or nothing that could be considered anti-Semitic in it. There's an Israeli flag and there's a reference to the occupied territory. But given the space that that is there within public discourse now, a pro-Israel organization can call this anti-Semitic, and I think the what's important is the continuing discussion on freedom of expression and the space for satire, and to see if we can find some kind of framework where we can judge, not only cartoons about Israel, but cartoons in general and satire in general, by which to judge them. Which will kind of make these kinds of discussions easier. So that's it. That's my input and my bit of rambling. I do apologize for that, but I hope I made my point a little bit. And thanks for your attention. And let's move to the debate.
Perfect. Thank you very much, Chair. And yeah, I think we can simply give the floor back to Andrei, who is going to moderate the debate, right? And I will just stop sharing my screen.